community, and she just said, like,
You know. I know. I felt like a lot of it was repetitive. And next week it's all about separate property. You're like, haven't we beaten this to death?
Right. I guess it's good, you know?
Yeah, it'll be good for the bar, I guess.
Oh, there's a refrigerator.
Did you want to sign? Am I supposed to sign you in, or are you supposed to sign? I figure you are, right?
Yeah.
Yeah, okay. I just didn't want that to get away from us.
Usually this is like the minute Victor comes in.
I know. Well, it's raining too, so
That's true.
everyone stops learning how to use their turn signals in the rain.
Right.
people don't know how to do that even when it's not raining.
Oh man, I don't know, especially out here. People have just been running red like blatantly.
Yeah, like it'll turn red and they'll already be going and just go through now.
And cars are still going. You know, I get it if you just didn't calculate it right every now and then, but oh, that's awful.
Victor did text 5 minutes ago.
Mm-hmm.
Oh, did you say?
No.
Oh, he said I'm gonna be a smidge late, rain delays.
Oh, okay.
So yeah, you called that.
All right. Not a problem. I figured that.
We can get started though.
Yeah, we can definitely still be here before the cases. We can start. Okay. So chapter 2, as you guys know, was about community property and kind of repeated what it said in chapter 1. So I thought it was pretty good, the cases that were included, although I think they were somewhat controversial because I felt like I could argue either side of the case. It wasn't just clear cut to me on a lot of them. But what the chapter 2 was talking about was basically community property systems. On the date of acquisition, you have to make sure the parties were married. Only married people can have community property. The property was acquired during the marriage, and the property was acquired by effort. And I think what they mean by effort is that it just wasn't inherited or gifted. That it was actually the community labor that went out there and obtained the assets or debts. And I thought this was interesting. It's on page 82, where it says one or both spouses are domiciled in California when the property is purchased. So, and the only thing I can think of is why they would include that is they're distinguishing community property from quasi-community property. And we'll go into quasi later, but essentially the court treats community property and quasi-community property the same. It's just a distinction, I think, to give somewhat of a full faith and credit to sister states, but then doing what the state wants to do with the property anyway. So I think that's why we created this quasi-community category. And so they talk about characterization. And so a lot of times you hear me use the word characterize, what's the character of the property? And that's really just to determine, is it community property or is it separate property? And those are the two categories that you would have. To divide property is to determine the spouse's shares in the community or community commingled assets. And I liked how this chapter focused on separate and community are totally distinctive. So you can commingle assets, and yet if you can trace them, they'll always be distinctive parts of an asset or a debt. And then they went on to talk about the community property principle again. And then page 84 is where they discuss California community property and quasi-community property. And so as you could see, community property, you pretty much know by now, it says, except as otherwise provided by statute, all property, real or personal, wherever situated. Again, that could be different states, different countries, wherever it's situated, acquired by a married person during the marriage while domiciled in the state is community property. And then they discuss quasi-community property. Again, that's page 85. And quasi-community property means all real or personal property, wherever situated, acquired before or after the operative date of this code in any of the following ways. A, by either spouse while domiciled elsewhere, which would have been community property if the spouse who acquired the property had been domiciled in the state at the time of acquisition. So that's just saying, I bought this property in Massachusetts, we moved to California, we're getting a divorce, and while Massachusetts doesn't have community property, we're going to impose California's community property on that state's property and call it quasi, because it's not a true community property asset. Or B, in exchange for real or personal property. That's like if you traded something in or exchanged it for something, it's going to have the same standard as how California would treat it. If you traded in a car in Massachusetts and later moved to California, they're going to determine that that car you traded in was quasi-community property. And as far as page 87, hey, are you? No, don't worry, we knew it's the rain.
I don't miss it during the rain.
You didn't miss anything but community property and separate property, which you already knew from last week. And so page 87, we were talking about community property ownership rights are not contingent upon getting a divorce, which is kind of a unique concept. So even if you stay together forever, you never get a divorce, your rights are still 50-50. So it does not only come into play when you decide to get a divorce. Thank you. And page 88, community property appreciation and rents, issues, and profits. Appreciation of community property is community property by the tracing principles. Likewise, depreciation. So you either make money together or you lose money together. I really enjoyed the section on community property presumptions. I thought that was kind of interesting. And that's page 89, just in case you guys were looking for that. And so the general community property presumption applies to all assets that are not otherwise governed by the more specific presumption. And it usually applies to untitled assets and to assets titled in one spouse's name alone. We see that a lot in community property. A lot of times it's just in one of the parties' names. And in the workshops that I teach at the courthouse, everyone thinks that means that it's theirs. Well, the car is in my name, so it's mine. And then I have to explain to them the community property presumption, and then they tell me how that's not fair. And the general community property presumption holds that property acquired during the marriage is going to be community property, absent some kind of proof otherwise. So that would be an inheritance, a gift, an agreement, transmutation, and the standard of proof to overcome the community property presumption, as you read, is just the preponderance of the evidence, which just means more likely than not. And our judges like to show that, what that means in the courtroom. So they're like, okay, here's a teeter-totter, and it's this way that is preponderance of the evidence, just a little bit more than the other side. So like 51% of the evidence is preponderance of the evidence. And I liked, and this is the first time I've really seen this, this analysis of preponderance of the evidence and why it's appropriate in most family law issues. And they're basically saying is you're kind of running the risk together. You know, if someone loses, it's going to be pretty close to either party losing versus the clear and convincing evidence where one would just have a total windfall. I thought that was kind of interesting, how they try to make it seem very equitable that it's preponderance of the evidence. And so that just leads us to our cases. So if anybody would like to present Wilson, or whoever was assigned Wilson.
Sure, that's me.
All right. And do you go by Will or William?
Will.
Okay, I thought Will, but then I thought maybe that's too casual.
No, it's
It's
fine.
okay, all right.
So this couple was married in January 1931. They separated in 1940, and the wife filed for divorce in January 1942. The community income was $6,000 per year. There's a difference on living expenses. The wife testified that the living expenses were $3,500 to $4,000 per month, while the husband testified that they were about $300 to $800 a month. So the issue here is whether the house was community property. The house was bought in 1938. The husband claims that the funds were accumulated from dividends from property acquired by him before the marriage. He therefore argues that it was error for the trial court to find that the house was community property. The rule is that there is a strong but rebuttable presumption that all property acquired during marriage is community property. Additionally, the burden rests upon the person asserting that the property is separate. Here the court looks at, they said whether the evidence controverts the presumption as a matter of law is a question for the trial court, and the trial court will be justified in disregarding appellate's testimony on the issue and finding in accordance with the presumption. So there's no conclusion actually stated. The case just kind of ends there, but it's pretty clear that the court's not overturning the trial court's decision to ignore the husband's testimony and to follow the presumption.
Mm-hmm. And I thought this case was right on. I didn't have any opinion one way or the other. Like the other cases, I kept going backwards and forwards, whether or not I felt the decision was right or wrong. But I thought Wilson was pretty clear and easy to understand. But did anybody else have another opinion of the case? Something they thought was unfair, or they didn't like, or they thought maybe didn't apply to the law?
No, I think that, I mean, he should have traced his dividends with evidence to overcome the presumption. Just your testimony can be just disregarded by the court, and that's not going to, you're not going to win an appeal because the court disregarded your testimony.
Exactly.
Essentially, most of these cases are people just didn't show the evidence.
Right.
That was exactly right.
The world could have been different had they done their homework and turned in paperwork.
And I wonder, like, when you go to an attorney and say, I want to appeal this, if an attorney does appeals, they might say, like, hey, you didn't present any evidence, we're not going to win. So, but this attorney seems like he ticked off the court a little bit when he was saying on page 92, counsel for defendant while giving lip service to these well-settled rules. Basically said none of this applies to our case, which was pretty funny. But you're right, it was just they presented no evidence. And then the other case that we were going to go over is fidelity. And for whatever reason, I just had a hard time with fidelity. I just didn't really care for it, but I'm changing your opinion. So, okay.
Well, no, I don't like the wife in this case. Just so we have a backstory. We have a gentleman. He buys some, I guess, plane insurance in case he dies, and sure enough, after he bought his insurance, he takes a flight, he crashes, but before he died, he mailed the insurance policy to his son as the beneficiary. But I guess the wife, who had been married to him for like 2 months before the crash, is saying, well, he bought it with community property money.
Right.
That insurance policy is mine.
Right.
And, they went back and forth saying, well, only half of it is yours because the other half would have been his. So they gave the kid half of it and held half until they figured out what was happening.
What to do with it.
But again, it was one of those cases where she didn't present any evidence that when the policy was purchased, that she was against it. And that's what kind of made it hard for me. Like, so had she presented evidence, would the ruling be different? Because right now she said, well, even though it was a community property money, it was a gift to the son, and that's his insurance policy.
Yeah.
So he gets those $5,000, which I guess was a lot back then.
Right. I know. I had to look at the data. I'm like, why are we fighting over this? Oh, I see. It was the depression.
The lawyers changed pretty good.
I know, right?
Yeah. So that's what I got from it. She didn't present enough evidence, but even if it was bought with community property money, it was gift for someone else, and then the other person gets to keep the gift afterwards.
The only thing I struggled with in this case was I thought the rules of community property were if you acquired something during the marriage, so he acquired this life insurance policy, right? That you presume it's community property unless you can trace it back to separate. So I always thought, the burden was on the person trying to establish it was separate. And I felt like they switched the burden in this case, but does anyone else have a feeling, or do they just say,
I was just like, well, you bought a policy, but you put someone else's beneficiary, and it's no longer community property at that point. It belongs to whoever.
And I do agree with that.
So,
I do agree with the beneficiary, but I also think that half of it could possibly be community.
I think it's hard to imagine that he doesn't have a dollar of his own money. Like, for her to say, no, that dollar was specifically community property just seems like a BS argument. Like, he doesn't have a dollar to their name.
But see, then I felt like they were married 2 months, right? So if the policy was like 10,000, I'd be like, oh, he had that money long before they got married. But because it's a $1 bill, I felt like he could have easily earned $1 during the marriage. And I felt like he had to trace the dollar if they were going to show it was separate.
Yeah, but he's dead.
I
I
know.
don't want to get into that because I'm getting on a plane. But still,
I didn't want to bring it up.
I mean,
You don't have a dollar.
I read that case while I was sitting in the airport, and I'm like, great. But I mean, how do you trace a dollar? Like, it's a dollar bill. He could have pulled 4 quarters out of his car that he's had in his car forever. I mean,
But doesn't that mean it's community then? If like you don't know where it came from, the dollar?
It's presumed to be.
That's where I struggle. I could be creating things that are not there. But that was my struggle, and I guess that's why I didn't care for this case. But then, as Will mentioned, you know, it's a 16-year-old kid who lost his dad and probably needs the money more than the wife of 2 months, and maybe the court was persuaded by equity. You know, is it really fair that this child's not going to have like an inheritance that the dad clearly wanted for the son, not the wife?
I feel like did they get married? She should have filled out the adoption papers. Well, she should have to take care of that kid for at least another 2 years.
Exactly right. Exactly right. So yeah, I don't know. I thought that was just one of the cases I didn't care for, but that's just my opinion.
Yeah, what got me was just like, well, I guess the partner had to consent or show evidence that she did. Because I feel like you buy something for someone else and community property money, it belongs to that person anyway.
I would say in a perfect world. Yeah. But I know my husband buys things all day long where I'm like, you could have called me and told me you're buying a car, but okay, you know.
Yeah, so, like if I get married and buy a car for my mom or something, I don't want my wife to be like, half of that car you bought for her is mine. I'm like, no, that's it. You can't be arguing for it.
Exactly right. Okay, and then the next one that kind of made me upset.
No, these all just upsetting.
All of these were upsetting to me, except the first one. I thought that one was pretty spot on. Like, you have to have evidence. I don't know how to pronounce the name. Etifa? Anybody? Etifa?
I got that one.
Okay, I'm sorry about that. You got lucky, right?
So basically, they were married. They were married in California. They ended up moving to Iran. And while they were there, the husband and his father seemed to have this property kind of investment business where the way that it was explained is the father gave the money to the son, and then the son bought the property and then deeded the property back to the dad. And so when they got divorced, the wife said, no, all that property that he bought was community property, and therefore I should be able to get it, at least half of it. At the trial court basically said, no, he met his standard of proof to rebut the community property presumption. And she said that there wasn't enough evidence given and that it should have been a higher standard of proof than just the preponderance of the evidence. The court basically went through and said they went through the case law that each of them gave and said that the courts struggle back and forth saying it's either preponderance of the evidence or it is the slightly higher one that is I forget the other one.
Oh, clear and convincing. Yeah,
clear and convincing. And the court basically went through and said that the presumption is based on the risk to the party and the gravity of the consequences that would result from the wrong determination. And they said here, it's just money. And that with a preponderance of the evidence standard and with money, they both have an equal right to lose the funds. They both have an equal right to gain the funds. And here they applied the right standard saying it was preponderance of the evidence and that it is not a higher standard. And so therefore she gets nothing.
Exactly. And then what did you think about the fact that, so these people obviously have a lot of money, right? And they seem pretty smart and shrewd with investments because they've invested a lot of money and made money. What do you think that, I didn't see that they presented any sort of evidence backing their claim. Did that bother you at all? Evidence of testimony. I mean, like financial documents.
Well, I mean, I think they don't really have to. I mean, if you get family, as far as a preponderance of the evidence type situation, I mean, if you bring in family that says, and they even joined the father in as a participant, they basically had enough just testimony that says, you know, no, this is how he acquired that property. So, I mean, if she wanted to rebut that, then she should have been the one that would have to give the evidence, I feel like. I feel like he met his standard to rebut the community property presumption. And if she wanted to argue that, she had to show something more.
Right, and I think her attorney could have pointed out that the dad was also benefiting from his testimony. So he was a witness, but he was also, you know, benefiting from it. So maybe his testimony could have been biased in a way, so he would get to keep the money as well. But do you think anything had to play the other assets that they listed in the bottom of page 104? You know, where they're talking about all these other things that they own together, you know, the ski chalet in Iran. I didn't know it snowed in Iran. I need to get out more. And seaside apartments in Turkey. Do you think that had any role in determining that these 4 properties probably were not community properties since they didn't have any other issues with the other assets and debts of the marriage?
I think she just tried to play dumb, to be honest.
Yeah.
I mean, they seem like they're successful. They seem like they know what the heck is going on. And for them to have all this property and for her to really say, oh, I didn't know that they were doing this, just seems kind of like a BS argument to me. I mean, they seem like more than the average divorcing couple at a Desert Hot Springs would be.
I couldn't agree more. Yeah, that case was pretty interesting.
I think she was just mad that he went back to California to get a divorce.
Probably. Very true. Very true. And then I guess we could go on to page 115, and that's just the statutory joint form title, community property presumption. So I just always find this one interesting, the special presumption, we just call it because the title is way too long. But it only applies in a dissolution proceeding. So it really only takes effect if someone is trying to divorce the other spouse. And what else is really interesting about the special presumption is that tracing is not going to cut it, which is pretty amazing. So the special presumption, as you guys probably read, is when an asset is titled in both names. So the general is either no one's name or just one party's name, and they're going to assume it's community. But the special one applies when it's in both the parties' names. And so I think the court really thinks when you start putting people on title, that's pretty clear that you intend to share that equally, divide it equally, and that's good enough for us to kind of impose that upon you, unless you have an agreement in writing saying, hey, I'll put you on title, but if we get divorced, this is still my separate property. And so that would be one of the ways that you can overcome it. Or if the title itself is pretty explicit, that the deed or the title makes it very clear that they're going to both be on the property and it's going to be both theirs. And typically that would be like community property with the right of survivorship. That's pretty clear that you're taking something that could be considered your separate and making it community. I mean, it's right in the title, the deed. So that helps out a lot. And again, tracing doesn't apply, but what you can use is a reimbursement. So if you have 2 people on a title, but let's say the husband had $30,000 in separate property for the down payment, that spouse, that husband's going to get his $30,000 right off the top. That's going to be reimbursed to him. No interest, but what he put in as his separate. So you don't need tracing, but you do have that right to have that money reimbursed to you. There was some good questions in here that I thought maybe I'd ask just to get your opinions on. So on page 101, question 5, and I actually have this case, so that's why I thought it was interesting. Question 5, does the general community property presumption apply to all property? Should it? and doesn't apply to biological materials like sperm, ova, or embryos. So, I mean, in this day and age, this is going to be more popular in family law. So, do you guys have an opinion on it applying to bodily fluids?
With exception of you as a person, that's not a commodity.
I've had this case, so you know.
Well, but to go back to that idea of effort.
Oh my God, you can't say that when I'm drinking.
I don't think that your blood and semen count as like I think it goes more with like
You don't know how they acquired it yet.
I don't think that there's a sufficient amount of effort put towards the...
No, Victor, can you please explain that for us?
Pass.
I'm showing you right now.
But I was going to ask that, as far as effort goes, is effort like you put in an effort to, like a community effort to get it, or is that more of just saying it wasn't a gift or inheritance?
I think it's more of it wasn't a gift through inheritance or gift.
Like you actually had to go out there and either buy it, make it, get it, something like that?
Right, because let's say if I bought a lottery ticket and I won $1 million and I was married long enough for that $1 is community. Don't even get me started on that case.
No, I'll pick up that case and be like, it's not community property, so.
I know, like boom. But so just my effort in buying a lottery ticket would still make it community.
Okay.
Yeah, very little effort, low threshold.
Well, the thing with like the sperm and the ova, it's like, did you pay for the freezing of it with community property? You probably be entitled to your costs because that's an expensive procedure.
It's
so
very expensive.
Probably you can't have the ova and the sperm itself. Maybe half the cost of whatever it costs.
Yeah, you would definitely want to argue that. Yeah, exactly. So when I was in private practice, I represented the husband. And did you guys ever see the movie Liar Liar?
Yeah.
Okay. So the ex-wife was like the one on the stand on Liar Liar, Jim Carrey's client. But she went to court and wanted to have the frozen sperm turned over to her that they had during marriage. Yeah. And she,
That's not okay.
and she lost, obviously, and I think everyone has the reaction of everyone in this room. But the judge is like, why would I do that? That is not necessarily like an asset. That's biology, right? And so I don't really see biology as an asset. And I just don't want to even go that route.
There was a case we had in the other with the real property with the hairy sickle cell. Well, like the cells are determined to be that guy's, even though the hospital extracted them.
True.
So it was part of who he was. It wasn't like a separate asset.
Exactly. And then there's that famous case. Who was that? Sofia Vergara. Do you remember that one? But they weren't married, so I think that might help too. But she and her fiance created embryos together. Now that's where it gets really, really weird because it takes both of them, the biology of both of them, to create the embryos. But the court declined to. They ordered those embryos destroyed.
No, that's messed up.
Yeah.
What was the argument? They wanted to keep the embryos?
That the boyfriend, the fiance, wanted to keep the embryos. They already knew they were girls. There's all this science I don't really understand, but he wanted to keep them and implant them in, someone down the road who he loved and have those as the children. And Sofia Vergara said, absolutely not. I don't want to have children with this person. And if those children grew up, then of course, then I would want to be a part of their lives too.
Well, and that's the thing. Like even with like the sperm, you can't order them given to the wife because then you're automatically putting the husband on the hook for child support. I mean,
and I kind of think
he didn't voluntarily do that to someone. Yeah, he voluntarily gave the sperm up, but that was to have a child with somebody that he cared about. If the child's not already made, I mean,
I actually wonder if he's wrong here.
Well, what if the child is already
if it matters if it's the husband or the wife?
No, I'm thinking, well, where do
I
you
mean, I don't want to get into politics.
Oh, yeah,
But if it,
yeah.
Well, it's into a pro-life argument. Is this embryo now a living thing where you should
True.
fight adoption instead of like trying to fight?
Right, that is true.
So, just have it implanted and fight for
but
child.
it's her choice to abort the embryo under our law.
Not when it's not her body. It's not her body, so it's not her choice. It's not in her body. She can't have it.
I think that's the political argument. It's not like the law, right? The law is that it's her choice, right?
No, it's because the catchphrase is her body, her choice.
But it's not
technically not in her body.
I can't stomach.
It's gonna be someone else's body.
I can't
right?
stomach it. No, it's a third person's body.
Third
But
person.
I think the law is just it's her choice, right?
Like in general, for
I think so. I thought so.
even outside.
I think that played a part in it.
I think that
because-
somebody has to be in control of the
I
decision.
thought the whole premise
And
of
the
it
law
being her
has
choice
placed
was
her in control of the decision. I mean,
the decision would be like you can't tell her what to do with their body, but this is no longer like
Yeah.
her body. It's just genetic material that they both consented to having mixed. So he now has 50% custody of whatever this little creature is.
yeah. I agree with Vincent that neither person should be on the hook for this if it does become a child. That's messed up.
Yeah, the sperm, yeah. Because that one to me is easier because that's clearly not mine, right? So, and I think you're right. I think she was looking for, this guy was wealthy. It was a short-term marriage, like a year. And if she had his child, there's 18 years of a lot of child support. But the judge declined, said, no, I'm not getting involved in biology.
That's cool.
Yeah, it was really good.
Yeah.
But I do think, and I'll look into that case about destroying the embryos, but I think you're right as far as the political argument versus the legal argument would probably be, she could have aborted the babies without getting consent from anybody. So maybe that's what it hinged on, especially, in California. But yeah, I thought that question was pretty interesting. And then there's another question on page 96. And so it was, what happens when a marriage ends after just a short time? Is property possessed by a spouse still presumptively community property? So and I think that's tied into really the fidelity case. Does that weigh on your mind? They were only married 2 months, even though it was $1, because they were married 2 months. Is that what bothers people and thinking she shouldn't get any of the life insurance? Let's say they were married 20 years. You guys would have felt better if she got half the life insurance.
Well, I want some kind of record. I want some kind of record that they had a previous relationship. It wasn't just like go through that had some paperwork. I guess what? 6-year-old kid get nothing.
Yeah. Yeah. I get that. I mean, that seems like the right conclusion. So I think they had to find a way to get to that.
To me, it seems like he almost bought the life insurance as like at the time of marriage. I mean, it's within 2 months. I mean, we're really splitting hairs, but to me, it seems like they almost kind of happen at the same time. It's like, I'm going to set up my kid even though I'm getting married. I'm probably going to give my assets to my new wife. So let's set up a life insurance policy for my kid. That way she can't actually disinherit him. To me, it seems like it's all planned.
Right.
You know what I mean? So
almost kind of eerie, like a premonition, right?
Maybe, but I don't. If I got remarried and I had a kid and I wanted to make sure that kid was going to get something,
right?
I may get a life insurance policy and put it in his name. That way, no matter what happens, even if in the end, even if I die 2 months later, you know what I mean? I don't know. To me, it makes sense.
It's $63,000 in today's time.
Wow.
63?
Yeah. So
Oh, wow.
It's probably actually more than that as far as what you can get with it.
Oh yeah.
Oh yeah. Yeah. Absolutely. That's true.
I get more back then.
Right.
Yeah, that is true. And then on the case, Vincent's case, Editha, was anybody bothered that it was raised that why was she in the dark about all these things? Did anyone?
I don't think she was.
Yeah, that's what I was going to say. Vincent thinks she knew and maybe willfully looked the other way. or didn't care, but she was aware of it.
I mean, it's just really brazen for the author to be like, well, he's violating this fiduciary duty to do everything. Like, he needs to tell her, he's concealing it. And I don't see how you can buy, trade, and sell 4 different sets of property with your family all under your wife's nose. I mean,
yeah. And I don't think they really even talked about what her statements were, really, you know, other than she just wanted a higher standard of proof, which makes it just harder to prove. It doesn't, they don't talk about her testimony in any way. You know, like if she was an abused wife who wasn't allowed to drive and didn't have any money of her own, you know, they didn't play into this is someone who had no power in the relationship. I don't have any clue.
I mean, they lived in Iran, so that might be true, but I mean.
That's what I mean, but they're totally silent as to what her testimony was, which other than I want a higher standard of proof.
No, I mean, this case is from what, 2001? So, or 2007. And they lived in America first, so it's not like I just feel like there's no way she could not have known.
Mm-hmm. And it all was, you know, deeded over to the dad during the marriage. I mean, like 3 years before the separation. So it wasn't even that close. You'll see this a lot in family law where people start deeding things like a month before they file for divorce. This at least was 3 years before. So I definitely double checked those dates to see if anything looked suspicious. Like, hey, Dad, she's going to leave me. I want to give you these properties. 3 years is a pretty significant time to have done it before the divorce was filed. Okay. Yeah, and that was that point, I think, that you were talking about, Vincent, on page 111, question 1, where the author says, only money? Is money all that is at stake in a case like this? Was husband Vahid required to disclose to wife Simran the fact that he was purchasing property during marriage, not for the community, but for his father? And I just didn't get the sense that what her testimony was about that. You know, that would have been interesting to know what she claimed she didn't know and how other business was handled amongst the parties. And then it says, as between Vahid and Simran, who was in the superior position to obtain records as to the source of funds that purchased the property. And obviously it was the person who was managing the property, which would have been the husband. Okay, so let's see what our next case is. Oh, I think it's Lucas, right?
Come back up.
Are you back up? Okay, you got Lucas. This is like the shortest case ever. It's like
Right.
1 page.
Do it.
Yeah, I'm trying to get it started.
There's no facts, Will.
I know.
No,
There literally are none.
statements.
Mix them up, it's fine.
In order to overcome the presumption and that something is community property when it's in a held as a joint tenancy or community, like held by title as some kind of concurrent ownership, let's say you have a contract that says that this is not community property or whatever. You have to have an understanding or an agreement. So like you have to have either contract or you have to have some kind of proof of understanding. You can't just go put it in your own name and then say it's community property. Say it's separate property.
Mm-hmm.
So you're going to be held to still the same standard of overcoming the presumption of community property. That's it.
Yeah, that was it.
Okay.
Yeah, no, you got it. That's why we're like, this is a weird case to try to analyze, but no, that's exactly right. And it was funny because in Lucas, so joint title is an affirmative act of specifying a form of ownership, and it removes it from being general. But then I thought it was funny at the end, the only findings in this regard are that neither party intended a gift to the other. So that's the only finding that they made. It's like, well, you both agree that it wasn't a gift, so that's my finding. Just interesting. Okay. Okay. Let's see. Let's see if there's anything good. And then on page 131, just a really important code section is that Family Code section 2640. That's under number 8 on page 131. It extends the right of reimbursement to cover separate property contributions to the other party's separate property. So that's always important to remember. That's a really interesting code section. So like when in doubt, if you have a case where you're like, it doesn't seem fair that you had to spend all this money, you could always look to that Family Code 2640 to see if you could ask for a reimbursement for those funds. Again, it's not with interest, but it would just be the amount that was paid down. And a lot of times you're going to need proof of it, like bank statements, any kind of financial documents to prove it, unless you're really good on the witness stand, apparently. So if you're credible, the judge might say, oh, you don't need any documentation. Okay. And then the statutory community property presumption for sums on deposit in any account of a married person. So this seemed pretty straightforward to me, and that's all deposits in any account of a married person are presumed to be community property. And that's California Probate Code section 5305A. And it really kind of makes sense to me that, you know, if you lose your spouse, financially you're probably figuring out, like, how am I going to make it? How am I going to pay my bills? And at least you know you have a certain sum of money in the bank. And so they're trying to give that person some guarantee that that money will be presumed to be community property, unless someone else can trace that it was all separate property. But at least that presumption is there to protect the widow or widower. So half of that account or all of that account isn't wiped out. Let's see. Oh, the lender's intent. I really like the lender's intent. I've never really, and it said it at the end of the case that you guys are going to discuss, Grinius, but I never understood why would a lender only want one person on the hook when they could have two. But then at the end of that case, it kind of hints at, by the way, a lender wouldn't do this because it puts them in a bad financial position. So I guess it's a very rare thing to have a lender's intent only want one of the spouses, not both, or rely on just one of the spouse's assets, not both. And it makes sense why it seems like it'd be rare, because why limit your ability to go after as much in the way of money assets that you can. Who was lucky enough to get Grinius? Oh, you poor thing.
I think it was too bad unless I missed something.
No. I don't know. I just thought it was a little.
That was just because my name matched. Okay, so we have this couple. You know, they have their. They call it anti-nuptials. That's
after you're married. Yeah, so
that's after you're married.
It's like a prenup, but after you're married, and a little bit harder standard because you owe a duty to each other once you're married. But, yeah, big question.
So yeah, they have an anti-nuptial agreement, which is pretty much saying that everything we owned before we were married is our separate property, and if we last 6 years together, then you know this contract lapses. We can renegotiate it, but we just ignore it, and after 6 years, everything's community property. So yeah, Victor and Joyce, they got together. They started this business up. They put all their money and effort into opening this restaurant. Then Victor put the title of the property that the business sat on in his name. Right? So he stipulated that the business was community property. The business itself was sold, and everyone got their share of it. But they found that the land that the business sat on was actually just Victor's property. And you know, Joyce argued, and they said, no, it's community property. Then they tried to bring in saying yeah, with the lender's intent. Well, you know, Victor probably uses his stocks that he had as backing for you know, this is why the lenders lent them the money, because Victor had good financial standing. But it's another case where they didn't show any evidence of it. Did they show any evidence as to, you know, did
Right.
they lend it to you because
Right,
of your
right.
separate standing? Then no, they didn't show any evidence. Well, guess what? It's community property. She gets half of the land asset. So
That's it.
yeah.
And I did like how this one I think had the most evidence out of all of them, though. But you're right. This whole chapter is like, have evidence, have evidence, have evidence. But I did like how they noted what they were looking for.
Like a writing from the lending company saying,
Exactly.
we're sending you as collateral for the stocks.
Right,
It
right.
was just collateral over the land itself.
And yeah, exactly. They had at least a list of things, and a lot were his, but it was also theirs together and hers. And so I thought that really kind of fleshed out the fact that they did not rely just on his assets, which was good. And
I don't know if you get a loan by your life, like a life insurance policy is
I know, a lot of,
But I didn't know that was worth something like that. All right.
yeah.
Get all kinds of money.
The more you have the, your income to debt ratio, the more you acquire debt, they're like, what do you have? They'll say, like, do you have any artwork? Yeah, they do. They like just look to see what they can take from
If
you.
you're still breathing, we take the money. That's fine.
Yeah, they'll take whatever they can take.
So I kind of have a question about like the loans though and stuff like that.
Uh-huh.
How come even if the loan is found to be separate property, even via lender's intent, how come they can still go after community property assets after depleting the separate property assets? Because at that point, I feel like you're penalizing
Right.
the non-benefiting spouse by taking their property, even though they have no basis to that, the funds that were given out, and you didn't rely on them at all to give out those funds.
Right.
How come they can still get to the community property?
And so that is very disturbing, especially for what we would call the innocent spouse, the one who didn't go and sign their name up for all these loans. But Victor was saying, they can go after half of the community property.
So like in court, can you say like, okay, this was community property, but this spouse defaulted, so the bank came and took this, so their share of the community property should be decreased by that amount? Or
yeah, they can put a lien. Let's say there's a home, they'll put a lien on the home. So eventually, you'll sell it and they'll get half of the equity in the home. Or when someone dies, they get half of the equity when someone dies.
But would the non-benefiting spouse be penalized, or would it come out of the other spouse's half?
The innocent spouse won't be penalized, except for the fact that sometimes they can force a sale if
okay.
And then you lost your home,
Yeah.
But the half of the equity would still be the innocent spouse.
Okay.
And they do that with tax returns too, just so you know. This is always interesting. Like if you get behind on child support, let's say you owe $10,000 and you've remarried and you have a new spouse, and child support will go after all that $10,000 when really only 50% of it should be gone after. And the spouse, the innocent spouse, has to tell the IRS, wait, you can't do that, I want my money. And then they have to give her 50% back. So child support can do things that most lenders can't do, but you have to specifically request to have half your tax return returned to you if it's a separate property debt. But usually they only go after the 50%. And that's why a lot of people declare bankruptcy, is to at least protect things like the home. So someone can't come and take your home. And I think you can have like 2 vehicles for a couple, and then they'll liquidate everything else.
Okay.
But that's why a lot of people do file bankruptcy.
So I'd rather have both people on the hook, that way they just take the whole house.
Exactly. Yeah, that's the thing. If they had both people on the hook, they'll take everything. They don't have to worry about 50%. It's just bad business for them to deal with one person when they can go after 2. So, and I think they even said that in here, which was great. It says here, And that where they said that was the bottom of page 145 notes, where it said they were talking to this person here from institutional lenders in Southern California. She found that the lenders rarely, if ever, rely solely on separate property in extending credit to a married person. And that if a lender in fact did so, they would be unlikely to admit that information because it is actually detrimental to the lender. So it sounds like they would have messed up if they only relied on one.
I think I worked in a bank, and there's a lot of loans where, I mean, we would just ask the one spouse. Like if it's a personal loan,
Right.
I mean, unless the only thing where we really asked for both information was if it was a mortgage.
Mm-hmm.
I think because they were both going to live in the house. But if we're giving you like a consolidation loan or something like that, we're only looking at the person who's asking for it. We're not looking at both.
Yeah, I do think the more money you're talking about, the more they want both parties to be on the hook. But a lot of times these personal, like Bank of America, personal loan, 5,000, 10,000, they'll look at all your information and determine if the risk is worth it or not. But usually when you start talking about like $500,000 here and there, or if that person's so far in debt already, they're like, we'd only be willing to take this risk if we could go after both of you.
Yeah.
Yeah, it's interesting. And then section 4 is just about the onerous or lucrative titles, which is kind of fancy. So onerous is just effort, like labor, burden. Lucrative is just the pure gift. And then this is the Clark case. I'm trying to remember if this case made me upset too.
This one made you upset?
No, I was okay with this one. It's the next one.
To say. I was say, you're an evil family law attorney if this one made you.
Not this one. I was okay with this one.
All right. So in this one, Mr. Clark's son died. However, in the son's will, it gave all of his funds to one of his friends. So he contested the will, basically saying, no, I'm entitled to it as his only like heir at law. And so while it was going through the appeal process, they actually compromised and said, okay, we'll give you $150,000 of his estate. However, shortly thereafter, he died.
Yeah, other one, right? Don't buy insurance.
Yeah, and so his family tried to get access to that $150,000, saying it should go through the line of intestacy because it was separate property. However, his widow said, no, this is community property, therefore I'm entitled to half of it. And the court because she argued that it wasn't technically a inheritance because he got it via a settlement.
Mm-hmm.
And therefore it should be classified as community property and not a separate property via an intestacy inheritance. And they said, basically, we have to look at where the funds came from. And here, they were coming from a will. And had he won at the trial court, it would have been classified as an inheritance. Mm-hmm. And so they said here, it basically it's an inheritance because you're getting it from a dead person. Mm-hmm. So they said it's separate property and it goes through the line of intestacy rather than the community property.
Right. Right. And then they asked the question on page 151, and it just says, if it had, where is it here? If it had, would the $150,000 be community property if the court considered all the work that Major Clark went into settling this case?
But I don't think Mr. Clark did anything. I mean, it's all his attorney.
Right.
He went out and hired an attorney and said, I want to fight this. And
mm-hmm. I think it was one of those situations where it was winner win all, lose all, and they realize, hey, $150,000 is a lot of money in 1928, right?
Yeah.
Well, let's both win, right? Because again, you could lose it all. So I agree. I don't think it probably was much in the way of Major Clark's labor at all. So
The widower, she wasn't the mother of the child, right?
I didn't get that. Yeah, I didn't get that feeling.
In the next CDTA.
Right. I think it was after a recent marriage. So I think it was a new wife. But yeah.
They said Major Clark was the sole heir, and so I mean, if it was the wife that was the mother, then she would have been an heir too.
Mm-hmm. Yeah, and so I like the notes at the bottom here where it says property cause of action is transferable. So a property cause of action is an intangible asset. If acquired during the marriage, it may be subject to the rules of community property. And what they were saying, like you said, Vincent, is that this essentially was an inheritance, and the claim really kind of arose before all of the marriage existed, and they didn't put much effort into it at all in settling the case. So yeah, that was a good case. I like that one. The one I really struggled with was this next one, and of course that's mine. Downer versus Bramett. Okay, I just want to know your opinions now. I can't wait. Did you guys think this was a fair outcome, or did you think it was unfair?
Unfair.
Well, did you have a feeling one way or the other if it was fair or unfair?
Yeah, I mean, I don't think that it's particularly fair. I mean,
Okay.
yeah.
Mm-hmm. Victor?
I think it was fair, but I just want to argue now.
I'll agree on that.
Yeah,
we can't all make
We
this.
can't all say it was unfair. I think it was unfair. I do. And this one was one of the ones that bothered me. So I'm not the evil family law attorney, since we all agree. But so this is the case where husband had worked for a company very long, was the right-hand man of the person that owned the ranch, and had worked for this company for decades. And so the wife had appealed from a judgment of non-suit on her complaint for the determination of her rights in certain property and for fraud. She claimed a community property interest in the proceeds of a sale of 1/3 interest in the ranch conveyed to her former husband by his employer after the parties separated. At the close of the case, former husband moved for a non-suit, and the motion was granted and judgment entered accordingly. Like, she didn't have a case. So when I read this, I was trying to remind myself, well, maybe this decision's just about the non-suit. Maybe they said, look, she should have her day in court and we might come up with a different decision. But then at the end of the case, it sounded pretty much like they're saying she should have an interest in the ranch. So that's how I read it. But the parties married in 1953 and separated in November 1971, so it was a pretty long marriage. And husband was an accountant and tax expert. He worked for the company before, during, and after the marriage. The corporation had no retirement program of any kind for its employees, and sometime in the 1960s, the boss told the husband he would give him and 2 other employees a ranch in Oregon instead of retirement benefits. But nothing was ever said again after that experience. In December 1972, a marital settlement agreement was executed, and the agreement specifically said all income and earnings of husband or wife after March 4th, 1972 should be the separate property of the acquirer, and that each party released any claim to that property. The agreement also contained language that neither party is now in possession of any other property or any other kind whatsoever other than the property specifically mentioned in the agreement. And so that one is a little bit of a catch-all too, but I'll get into that later. In August 1972, before the parties executed the agreement, but after March 4th, the boss deeded the ranch to former husband and 2 employees. Husband claims it was a gift, and wife was claiming that it was actually in lieu of a pension, which she would have been entitled to. And so I found it interesting that the court went on and on about how they had a professional relationship. The husband and the boss had a very professional relationship and did not really socialize outside of work. But then went on to discuss, well, he did go to the boss's daughter's wedding and he did house sit for the boss. And so I think really it could, in my opinion, it really was a gift to the husband because he appreciated all his hard work and his effort and probably liked the person. And the Court of Appeal goes on to basically reiterate what we're saying here. It says, Court of Appeal agrees that 1/3 interest in this ranch was legally in the form of a gift. Just says it right from the back. Code section defines a gift as a transfer of personal property made voluntarily and without consideration. So the court there, by saying it's a gift, said no consideration was made for this ranch, but then talks about all the labor and the work that was done to get the ranch, which is, in my opinion, consideration. Like, I worked for you for 30 years, that's my consideration. But the court says there was no consideration. The boss had no legal obligation to transfer, no contractual obligation bargained in exchange for one another. The husband did not detrimentally rely on the promise that I'll give you a ranch instead of a pension. But however, they went on to say that earnings or property attributable to or acquired as a result of labor, skill, and effort of a spouse during marriage are community property. So I just found, I was like, they went into all this analysis of it's a gift, and he had no expectation of getting this. And then he got it, and then they said, oh, well, you worked hard for this person, so we're going to give wife an interest in the ranch.
Right, so I don't understand the analysis is the part that's screwed up. It's
Yeah.
like either you look at these dates and
Right.
you say, this is not a non-suit, this smells like fraud, you know what I mean?
Mhm.
Which I think the dates, you can say, we're not gonna grant a non-suit because we wanna see if she can prove fraud.
Right, and I wondered about that. I wondered if they denied the non-suit and had a trial, if the result would have been the same, like he gets to keep the ranch.
I mean, these dates, if I were a juror sitting there, these dates would pique my attention. But then, obviously, like, you gotta put the boss up there and swear him and, see what he says,
I don't think you can harvest after a divorce. It's like once you divorce, you can't get anything
But the
else.
thing is, though, is that he said they transferred this right after the divorce. It looks like they waited, came to a settlement agreement, and then months later he came into his whole retirement based on. I mean, I'm arguing for the court here, basically.
Well, they went back to proof fraud. Maybe maybe if he initiated the divorce and said, I want to divorce him, then later it just had to get the property. But.
So I wonder if tossing it back and forth with this really screwy analysis is intended to not make a decision. Intended to say, well, they said this, they said this, they said this, they said this.
Right.
I mean, and in the end, we're going to overturn the non-suit.
And I wish they would have focused on, for me, certain things pop up. And so one thing popped up for me is just the disclosure requirement. So even though it was after that date, March 4th, 1972, when everything you have is yours, that's in the agreement. But then it wasn't signed until December. And so in the agreement, it says, where did I put that in here, that neither party is now in possession of any property of any kind or description whatsoever, other than the property specifically mentioned in the agreement. And so that was already after the ranch was deeded to them in August. But I feel like, shouldn't that have been mentioned? Like, oh, I'm signing this agreement, I have nothing else.
But at the time, did he know he had that property? Because then it might be fraud.
Well, and that's what I was wondering, that it didn't really focus on that at all, is why we could try to set it aside for fraud. And that would make more sense.
Yeah, that's the only way I can see it making sense. Other than that, because
that's what I would have done.
Because if I get married now, then guess what? I open up a practice, but we divorced 5 years in, and practice does nothing. But then later, become a billionaire with my practice. I don't want to come back and be like, well, I was there when you started it, so half of whatever your practice.
sign. Well, that would be different. I mean, but what if you like said that the practice was only worth blah 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 blah, but you had cases in the pipes that were worth like millions of dollars, and you already worked on them, but you hadn't received. You haven't like classified. I'm building a fraud case, but you haven't like you haven't like come into the $10 million final judgment yet, and you're hiding the fact from the court, and you come and do it.
Doesn't it have to be relatively certain that you're going to get whatever you're going to get in order for them to come after you for fraud? Because I mean, like in a personal injury action, yeah, you may think your case is worth $1.2 million, but you don't know what you're going to get until that jury returns the verdict. I mean, so how can they classify it as fraud if you're not relatively certain that it's going to be yours?
Fraud is that they didn't disclose it. So, and that's on page 152, that August 1972, before the parties signed the agreement, but after that March 4th date. March 4th said anything after March 4th is yours. But they signed the agreement December 1972. So he got the ranch in August, and they signed this agreement in December. So at least he had a few months to know he was deeded the property. And in the agreement, it says, we guarantee each other we don't have anything other than what's listed in here.
But he didn't have it, though, because it wasn't given to him yet.
Well, it was deeded in August, though.
Oh, it was deeded in August, and then
Yeah, it was given to him in August, and then he signed his marital settlement agreement in December.
Oh, yeah, then she has a case then.
But I wish they would have focused. See, that's what I mean. Like, what are we focusing on? Like,
no, they're focusing on the fraud. Then this dude committed fraud.
Exactly, and then we would have been fine with it.
But
Yeah, I mean.
Had the disclosure been signed and then he got deeded, well, you don't have a case.
Oh, totally.
Okay, that makes way more sense to me now.
Right. Yeah, exactly. They didn't word this very well. They should have been like boom, 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 like with the dates. You have to like search for it.
Yeah.
But yeah, if they just focus on, hey, you had a duty to disclose you had an additional property and not just hide it, then I would have understood the ruling. But I didn't like the whole, it's a gift, but it was in lieu of a pension. What? Did you earn it or was it a gift? Right? So this case probably upset me the most.
It seems like they should have said less. They should have just said
Yes.
like, like they kind of rambled on and convoluted the issue.
Just don't lie on your disclosure form.
Yeah,
That's the whole.
Yeah.
That's the whole.
Don't lie to the time you're signing agreements.
Yeah.
Or else we're gonna allow them to sue. Maybe we should come back with nothing, but.
Right. And
we'll
so
see.
It makes way more sense because it didn't make sense to me that someone can benefit from something I get after the divorce. I'm like,
No.
After that, never. Yeah.
Totally agree. And I think if they signed that agreement in March, they would have been fine.
Right.
So just wait.
They dragged it out.
So why would you disclose it if you acquired it after the date that you've already said it's already going to be considered mine? I mean,
because now you're sitting on a huge pile. I mean, to me, I'm just saying that the non-suit was error.
Oh, yeah. Well, that's what the
I'm not saying that it wasn't a gift. I think it might have been. I mean, I'm just saying that at this point you have a concealment, you have a fraud by concealment issue. At least it's triable.
Well,
right.
Why would it be concealment though? Because I mean, you've already come to the agreement that any property received after that March 4th date is going to be yours. So even if you were to say, okay, yeah, I got it, I mean,
I think it's basically a
March
partnership.
4th date, so it's still mine. I mean, I'm not concealing it.
You
I've already determined that.
I totally agree. If they just kept that anything after yours March 4th, it would have been his. But then, lawyers are tricky because they're always afraid that one party's not disclosing things, so they want to have like another way to get a second bite of the apple. And so that's where it's in the middle of the page of 152. It says, however, the agreement also contained a warranty that neither party is now in possession of any property of any kind or description whatsoever, other than the property specifically mentioned in the agreement. And so that was signed in December, and when he signed it, he was already deeded the ranch back in August. So that's why I think it's fraud. Or at least mistake, which means you could go after that asset.
Did he know it was deeded to him, or because he can deed a property?
Oh
without
yeah,
having
these cases need way more detail.
Yeah.
I'm assuming if they like just say it was deeded, but
It's
yeah.
listen,
I don't know.
David, do you have a fiduciary duty at this point in the?
You do.
Okay.
Yeah,
You put it in like a general partnership we learned last night.
yeah,
But, I mean, marriage should be,
exactly the same.
yeah, even higher.
These aren't good marriages.
Well, and California looks at it as like a business or a corporation, when they call it a partnership with intimate aspects of the partnership, is what they say.
Well, it's terrifying now because now I get why people want to check credit scores first and everything.
Yeah, exactly right. Exactly. So yeah, I thought these cases were really good for like discussion purposes. Why are we getting through this material so fast?
With that awesome.
Are we just that efficient?
Mm-hmm.
So I guess, did you guys have any other questions about any of this?
I still think the embryos are more of a custody issue than a channel issue.
I think you can make that argument. I do.
Throw them away.
They do that with living kids even after they're born. Like, nobody
Throw them
wants.
away.
Nobody wants to be a single. Oh, I was on the radio today.
What's that?
Like, this couple, like they're splitting up and they had a kid. And nobody wanted to be a single parent, so they sold the child.
What?
Yeah.
Like into slavery?
Okay, that shocks. Wait, embryos. Okay.
Well, it's a little different. I mean, like,
They had a 3-year-old kid and the couple separated. And they sold them for like $13,600.
where?
I didn't get the. This was just on the radio, talk radio. I didn't get all the details.
Wow.
But I was like, yeah, what if you're divorcing? Neither one wants the kid. It's
Oh
funny.
yeah, it does happen. It does. That's what we have
Well, you don't get to sell him. Like,
Oh, so you can throw an embryo in the trash. This is essentially a kid that just has to be gestated. It's just.
I love it. I
you
love it.
don't get to sell those either.
So they throw it in the trash.
I don't think that I'm being intellectually like screwed up here. I'm saying you don't get to sell them.
Listen, this is America. We're a capitalist society. I can tell.
Oh,
So we're not allowed to profit from
You know,
it.
it's a higher value of use. You know, it goes to somebody who will abuse the kid harder. So higher level of use.
Oh my
Right?
gosh. So, and then the notes, I mean, you guys probably already know this and read this, but they're saying deferred earnings. So this is what they're considering it as, like a deferred earning, even though it was never contracted for, even though no one had any idea that they were going to actually get any kind of earnings. During marriage are community property. And one of the most important rule of community property characterization is labor during the marriage belongs to the community. So this was like what we were talking about last week, how someone goes and works 2 jobs and the other spouse is like, I'm just gonna stay at home because I don't have to work, they make enough money. That belongs to your spouse on the couch.
Yeah.
Yeah, so keep that in mind.
I need to find a sugar mom.
I want to be the spouse on the couch.
I have a friend who always says I need a sugar daddy. And I'm like, oh, I know one. And I'm like, here he is. And she's like, I don't want a sugar daddy. No, thank you. It's not worth it. I guess we could go over the chapter summary. And then what I was told is you guys can start reading next week's assignment. I just don't know how, like next week we only have 38 pages. I think because these chapters are long, but the information's short, that's why we're getting through it so fast. I don't know. But I guess we'll just go over the chapter summary. Community property is any property acquired during marriage by the effort of one or both spouses while domiciled in the state. Property acquired during marriage by effort while residing in another state is quasi-community property in California, dissolution or probate proceeding. We get that a lot, especially from other countries. We do get a lot of people who have homes in Mexico. As long as they lived in California during the divorce, we can actually have those homes in Mexico sold even.
So, what is it better? Do you know if it's better to file for divorce in Mexico? Or?
Probably. Probably. It's a whole lot easier too than California. So I know like a lot of people that I work with, their spouses are in Mexico, and so they live here, but their spouse is in Mexico. And so to serve someone in Mexico, our court has to ask Mexico's court's permission to serve that person. And then their court goes and actually serves the person. And it delays service for like 6 months to a year.
But
So we usually say go to Mexico and get a divorce.
it's the same thing in Florida. We were trying to serve a guy in, or to subpoena a person in Florida.
Oh my God.
And they follow this rule from like 1913, it's like original uniform code that basically said that you have to follow the rules within that court. So we have to go to that court and make them follow the rules of it. Like, we can't go into, Florida's like sideways. But
Florida is sideways. They are. There. I had a case where the husband and wife were married. Husband dies in Florida. Wife lives in California. Daughter in Florida says, "My dad was never married, for will purposes." So the wife in California is like, "We were married," and so Florida said, "Well, you better prove it." And she's like, "Well, I have my marriage license, right?" No, you need a court order. Well, what court's gonna order you were married?
That was the problem, is that we need the court to tell that court.
Right.
But our court won't tell that
They
court.
won't.
Yeah, so we can't.
That was the same issue.
We can't go to Florida and say, "Will you please make your guy do this?" No, you gotta get a court order from your court telling our court to do this.
Right.
And
That was
then
exactly
we'll
the
listen to
same.
your court.
And our court's like, "I'm not gonna make a finding someone is married."
Yeah.
Like, go down and fix the records, right? No, it's totally different. Yeah, every state has their own little quirks, and countries too. Date of acquisition is key to the characterization process. So always think of, okay, when did we acquire this? Only property acquired during marriage is eligible for characterization as community property or quasi-community property. California uses evidentiary presumptions just as with characterization. Labor belongs to the community, so the housekeeper's presumption holds that both spouses contribute to the acquisition of property during marriage. The housekeeper's presumption is conclusive as a matter of policy. And all that means, that's very, very fancy for like, you can't rebut the presumption that you both are entitled to each other's labor. It's just one of those things California says, you can't prove someone's lazy. It doesn't matter if they're lazy.
You can prove it.
You can prove it, but the judge is like, I hear this all day, it doesn't matter. The California Family Code Section 760, General Community Presumption, applies to all assets that are not governed by a superseding presumption. That's that special presumption. And predictability, this means that the general presumption applies to two asset categories, those that are titled in one spouse's name alone and those that are untitled. The general presumption is rebuttable by tracing the acquisition back to separate property source. It's also rebuttable by an agreement between the parties. So I guess that's why, this is that one where I'm coming back, I'm gonna harp on it again, that whole life insurance one bothers me. But anyway, we'll move on. The California Family Code Section 2581, Special Community Property Presumption, applies to assets that are acquired during marriage in any joint title form, which makes sense. I mean, you're kind of leading the other person on to say like, hey, this is ours. And then you get a divorce and you're like, no, just kidding, it's all mine. So it makes sense that they need to have either some express writing in the deed that if they get divorced, it'll go back to separate, or if they have another agreement that says if we get divorced, it's gonna go back to separate. Sometimes people do that. I mean, you guys are probably thinking like, in what scenario would people even want to do that? Some people do that like to refinance, get a better interest rate, and they put their spouse on the deed. Like, just pay the extra interest, right? But that's usually where that kind of comes in. Like, we'll get a better interest rate if I put you on the home. So that's why you need to have that separate writing. Say, but if we get a divorce, you know this was my home, my separate property.
So can you accidentally like make your house community property. Say I have my house, right? Say I get married and she moves in. Can that accidentally turn? If I say it's our home, our house? Or
Not so much the wording of it, but where you could get in trouble is, well, so let's say you had a home before you get married, right? And then you get married and your spouse moves into your home. And you're kind of doing your thing. You paid the mortgage before you got married, and you paid the mortgage during marriage. So nothing changes. But the minute you get married, 50 cents of every dollar you make is your spouse's. So she's paying for the mortgage. So it wouldn't be community property, but we call it a community interest. Where she's like, look, I helped you pay down your separate property. I want reimbursed for what I helped you pay down, even though it's just your paycheck, which a lot of people are like, that's insane.
Once I'm governor, we're becoming a separate property state.
I will for you, but you know.
So a lot of people, they're doing that because she's not actually writing a check paying for half. It's all your income. But sometimes the courts are pretty good about it. So she might say, look, I want to be reimbursed for half of the principal I paid down.
So question. So if I get married, and let's say that I'm a lawyer and, you know, a housewife, which would be wonderful to have somebody that one person making enough money, the other person can stay at home. And we use my check to pay off my student loans. She can then ask for that to be reimbursed.
She could.
Because that's my,
yeah, she could ask for a reimbursement. Now, I personally never seen that. I've never seen, because it's very common, like I'm paying down my student loans, we're both benefiting from this law degree. So a lot of times the judges are like, we're gonna kind of narrow what you can be reimbursed for. Typically it's half the principal of a mortgage, not even the interest, just the principal. She can ask for half of it back. But the court can say, look, you're gonna pay rent somewhere else anyway. So what would you have paid in rent? $1,100, and then what did Victor pay a month for mortgage? $1,100, so it's a wash. So if your mortgage was really high, let's say your mortgage is $4,000, and you were paying the $4,000, and she says, look, I could have rented a place for $1,000. Then the court's like, you owe her money.
Don't get married.
Just always have a reasonable mortgage.
Assuming the house is paid off then. The house is paid off?
Okay, so the house is paid off, and then you get married?
And she moves into that house.
Oh, you're fine.
Fine.
Don't put her on the title.
Don't put her on title.
Don't put her on title.
You're gonna say it's our home, our house.
That's fine.
Divorce. Bye.
Yeah, exactly.
Okay.
Yeah, that should be all yours.
So
where it gets weird is if like you put a second on it, and now you're married. Yeah, so just be careful with that stuff.
Now to go to Will's question with the student loans.
Yeah.
Can I get married with like $1 million in debt and student loans and then divorce and she gets half of that?
No, that's the kicker. Yeah, that's the kicker. I know, that's the kicker. Yeah, so you could ask for a reimbursement for, and this is the other one, child support. So sometimes you'll marry a person who owes $20,000 in child support, and husband and wife or spouse and spouse are working hard to pay off that child support. The wife then can ask to have it reimbursed if they divorce. Like, I helped you pay off $20,000 of your child support. Typically, the court wants to see that parent had separate property funds they could have used and didn't use.
Oh, okay. That's fair.
So that's pretty fair.
Yeah.
Like, if they just held on to all their money and used community, then the court's like, no, that's not fair. You should have used your community. For whatever reason, that's kind of limited to child support and not other things, but yeah, it's interesting. Usually where it applies, the reimbursement is like a down payment on a home. Like, I use my separate property money to buy the home. I get that money right off the top. So if we sell a home and we get $30,000 in equity and I paid $30,000 for the down payment, I'm the only one getting money. We don't have to split the equity.
So I have a question. What if you have a home and you've paid on it quite a bit, and then you get married, and then you continue to to pay on it with your own money.
Right.
But not your own money, but now community money.
Right.
And then they get divorced.
Uh-huh.
So the equity of the home needs to be traced from before and after that date with the
like
spouse.
the increase in equity that they helped you achieve.
Well, no, the new spouse coming in. This is like my sister's situation. So
That's very specific, Will.
Wow, this is really good.
She's very good imagination.
the new spouse, even though like previous job, previous house, previous money going into that house, already like plan schedule payments and just continue. He actually owns half of the value
of the increase in equity.
After increase in equity, sure, but he owns. Yeah, but see, how do you split that? Like you just.
It's the Moore Marsden calculator. So it's a really, really complicated formula, but you can go online and look at Moore Marsden and it'll just ask you like questions and you plug in the numbers. So a lot of time, like you're helping somebody pay down their mortgage and at the same time the home is going up in equity. They're saying, well, I helped you reach that equity. So I get a percentage of it. Okay. It's not just like we're gonna split the equity in half. So like you're saying, what was it worth when you got married? What's it worth now? How much did they pay for the separate property contribution? What's the mortgage? What's the principal?
So this test would take roughly half of all the equity acquired after that date. I mean, with those bars and
Okay. It's like an interest. So, because it's not really like a community property asset where you just split it in half, it's more of like an interest that is this really awful formula and the computer spits out a number. So I don't think it would be half the equity because that's essentially robbing her of having separate property.
Well, no, not half the equity, the whole thing. I'm saying half the equity post-marriage.
Which would still be like robbing her of a separate property. Okay. You know what I mean?
Sure,
so like if you're married, if it was your separate property for a year, that should still be your separate property. And so they would just have not a nominal interest, but less than a 50-50 interest.
Okay.
And it's all based on the numbers. So it usually spits out a number that they'd be entitled to versus just like half the equity since date of marriage and date of separation.
I need to get her tied up before they marry.
Is she really going through that right now?
Well, no, she just got engaged.
Oh, okay.
And he's like, what do I do about my house? I know.
Like,
what do I do about my house?
Because
I think you should just tie it to a trust and just act like, what? Keep on.
Oh yeah, put
you
it
know
in
what I
your
mean?
parents' name or something like that.
Yeah. Well, and then if they have a kid, eventually put the kid as the beneficiary.
Right.
But leave it as my mom or something.
Yeah. And also do that like with healthcare derivatives too. I always say just put like a family member in charge of your health versus a spouse. You know, like who's in charge of pulling the plug on you. I would just always give it to a family member.
Why?
You remember that Terry Schiavo case where she was in a coma and her parents fought so hard to just have the right to keep her on a ventilator, and the husband they were still legally married, but the husband had already moved on and had a girlfriend and had kids with the girlfriend, and he was the one in charge of being able to pull the plug. And as a result, he inherited all of her assets.
I'm gonna get DNR tested.
Right? Because, if they got divorced, they could still get divorced even though she's in a coma. Because, Florida's different, so I'm just going off of California law. So let's say she was in a coma in California, they could still divorce her, and typically a family member would be her guardian. And so her guardian would be fighting for her just like an attorney would to protect her rights and assets, even though she couldn't participate at all. So they could have still gotten a divorce, but think about it. Why would you want to divide half of your estate if she passes away, you get all of it? So that's why I usually say, like, make sure family is not going to try to cheat you like that. Spouses, if they've moved on, you're dust, So, yeah, that's just like a little practice pointer. Anyone have anything else to say? That case is so interesting, the Shiloh case.
Instead of a DNR tattoo, I get like a bank routing number and no signatures as any means necessary.
Just right up, it says DNR. It's like, wait for the paramedic to tear that open and be like,
You're like, oh, man.
All
I like a
right.
signature. I never a signature tattoo.
No, I want the paramedic to open it and be like, open it and be like, save this guy's got money. Put him in front of the list.
Oh my gosh, let's see. Okay, California Probate Code Special Community Property Presumption applies to sums on deposit in any demand deposit account of a married person. The presumption is rebuttable by tracing sums back to separate property source or by an agreement between the spouses that specific sums in an account are not to be community property. So that was that one example of when someone passes away, it's presumed that the money in the account is community, unless someone can trace that it's not. And like, I think, was it you, Vincent, that said like, he's dead, who's gonna trace all the documents? So I think it's kind of like an unfair advantage, unless one of the spouses is an attorney and says to the son, here's all my tracing materials. You know, doesn't usually happen that often.
Not just throwing his cash after you get married, you can always just have it.
Right, that's what I like to have those records. My husband says, who uses checks? I'm like, people who keep tracing documents. The burden to rebut a community property presumption is on the spouse who claims the property as his or her own separate property. And that makes sense to me. So I don't think that one's difficult to really understand. It's like if you're claiming something's unique about this asset, you better be able to prove it. Owner's title is community property and character. That's just labor. And lucrative title is separate property and character. Those are like gifts and inheritance. So it's only 7:30.
No, it's 9:30, so we can go home.
I see Vincent fading, like it's 9:30. I'm wondering, do you guys want to just read our next week's assignment and leave instead of take a break? What do you guys want to do?
What do you mean, like, leave and stay here and physically go? I was like,
I know, I'm like, I
I
don't
think I want to read.
What do you guys do in your other classes with 3 hours?
we've left,
Well, see, Drucker has like a big, like, hour-long speech.
Drucker just will waste our time. But
That's crazy.
when we had Dolan last semester, we left at 7:30 a lot.
Really?
Vincent, when we had trial advocacy,
Basically, we're here until we're done, and
when we had trial advocacy,
trial advocacy, we were gone by like 7.
Okay.
Well, we come in and just check our binders and leave.
we literally come in here and spend like 30 minutes
Uh-huh.
and like have left.
Because I feel like if we've done the lesson, I don't know like how much I need to tell you community properties family code 760. You want to hear it again? I love like Vincent. He's like, you look tired. You look so exhausted.
I got like 3 hours of sleep last night.
Well, I'm fine with it because we got through our lesson plan. If we didn't get through it, there'd be no way we'd leave early. So, or you can stay and read, whatever you prefer.
I'll stay and read.
Vincent's like, I'm reading, bye.
You just gotta like freeze the frame right there. This is gonna pause.
Like, it hasn't moved or blinked in hours. Oh my God. All right. Well, I'm fine with that because we're through. And it was, the first 2 chapters have been very easy. So I think as they get more complicated and less repetitive, we'll probably be taking the whole time.
There's gonna be custody in this book.
No, I wish there
Yeah,
was.
because that would be.
It would be amazing
If there was what?
if there's
Custody
custody. Like family law issues would be so amazing. That would take the whole time.
Yeah.
But community property is like a small sliver of family law. So that's why I think we're getting through it so quickly.
It just seems like it's all money. There's no actual.
And I can't make you guys read like 150 pages a chapter or of work during the week.
That isn't.
Yeah, that won't work either. So I thought 75 would take 3 hours, but
The custody stuff is actually really interesting.
it is. It's
I
really.
haven't seen it here. This is, I guess it's community property law. So it's not family law, it's community property law.
I think they should increase it to family law, really, because the custody is that interesting stuff.
So can you have like an agreement where if you file for divorce, you have to take all the kids?
It's not enforceable.
And you don't get any money. If you file for divorce,
No.
you have to get the kids, you don't get any money.
Yeah.
This seems unconscionable.
Yeah.
But it'll hold the marriage together.
You even take them, yeah, that's true.
And here's like a little
Also
trick.
prison.
Yeah, here's a trick. Like the trick is, look, I won't ask for spousal support if you don't ask for child support. And they're like, okay.
Well, that's a different right, because it's a child's right. versus,
Exactly.
It's
And
not
so
a
they're
fair,
like,
it's not an exchange of it's not fair consideration.
exactly.
You
And
don't
it's
offer
not your
someone else-
money.
It's
Right.
not your money,
It's
yeah.
not your money. So, but a lot of people don't know that. And so they'll give up spousal support because you're not coming after me for child support. The next day they turn and file a request for child support.
Sure.
And the judge is like, that's not enforceable. You can't give up your right to child support ever. You can set it at 0 or reserve on it and come back later when you need it, but you can never give it up.
So you have to phrase it differently, no spousal support, but set it at 0.
Yeah.
And it's okay.
And then that's okay. Exactly. But you could always come
But
back.
you could say,
on
like,
child support.
But like a fair exchange of detriment would be like, you keep the house and you don't come after me for child, or you don't come after me for spousal support.
Mhm.
Because that's your benefit for your detriment.
Right.
Like that's-
Exactly.
Okay.
And then it depends on how you write that agreement too, because some judges, in California, if you're married over 10 years, some judges won't terminate spousal support.
Oh.
And they'll set it at 0, reserve on it, but they're like, no, it's a right. If you got in a car accident, we want you to be able to go after the other party. So even if you get the house, you just have to make sure you're very, very clear that you knowingly and intelligently waive your right to spousal support. You understand under no condition will you ever get spousal support. Then usually the judge wants to talk to you and make sure you understand it, and then they will sign the agreement. But it's really more challenging. And some judges won't sign it at all.
If you file for divorce, you have to take the kids.
But then the marriage vows.
I
You enter into this
I
contract.
get a free start if you file for divorce.
Right?
That's a move away.
Some judges are like, no, I'll sell the house, we'll split that, and then you both are on the hook for spousal support potentially forever.
Yeah, the judge says that until they go through their own divorce and they go, oh crap.
Oh yeah, they keep coming to the court every other month, and they're like, I should have signed the agreement.
Yeah, exactly.
You prenup to avoid the spousal
Right.
support, right? That's what the prenup is?
Yeah.
Is this-
It can't, a lot of times prenups regarding spousal supports will be unenforceable too.
Still,
I don't know what it is about other than they don't want you going on public assistance.
that's the scary part. It's like, well, what if you cut ties? I kind of just want the ties to be cut.
Right.
You know,
Right, and that's why a lot of people aren't getting married anymore. I would say half of the people I see, if maybe 60% now,
So,
aren't married.
so a question now, do you think that the law is actually supporting marriage? I mean, because like, I thought that marriage used to be considered a policy good,
Right,
and
Right.
and so like the law was supposed to by
kind of
policy
encourage it.
encourage
Yeah.
the stability in marriage, but now it's like,
I wondered that myself because the state is not allowed to do anything that discourages marriage.
Right.
And yet these laws have discouraged a lot of people, making it harder and harder.
but it's a law though that's passed. So like, are policy considerations supposed to come into effect after you take the law at its face value though, right?
I think so. Well,
Like, or can, I guess there are instances where the
Uh-huh.
law is overturned for being
Right.
public policy.
exactly. I think it's kind of a balance. They try to look at it over and over to see if we're still within what we wanted to do with our policy goals. But I always wanted to teach a class like this for people before they got married. No, you can't do that. That would discourage marriage. You
I
can't
wanna do that all
discourage
the
marriage.
time.
Yeah, you can't discourage marriage in California.
We're not talking about the law.
Yeah, we do parenting classes, right? Yeah, so I know it's really kind of a strange situation, but I still would like to know why the other 41 states don't have community property. I'd like to know more about, because it is way more work for the judges.
Because
To
it's
not-
not fair.
I'm sorry?
It's not fair. 50% of my paycheck is not theirs.
Exactly.
Just get married in a different state, right? That's their license or something. That's what thing, right?
If you-
No, because as soon as you come to California,
So domiciled in the-
you
I'm moving.
Well, you might want to do that for tax purposes anyways, you know, hold two domiciles and just
Yeah.
act like you, I'm sure it's not gonna work.
By the way, that's what we're studying for. Right?
Well, get some good rest, Vincent.
See you next
Bye,
week.
guys.
Thank you.
Yeah.